It is a pleasure for me to make a brief description of the so-called Rome III decision and regulation on the law applicable to divorce and legal separation. Before beginning my presentation, I would like to mention that I am responsible for judicial cooperation in civil matters in the General Secretariat of the Council of the European Union. Before going to more legal issues, I would mention that according to the figures presented by the European Commission, many marriages in the EU are international. As an example, in the year 2007, there were more than 1 million divorces in the 27 member states of the European Union, of which 13% had an international element. In my presentation, I will speak on three general aspects: the general context of Rome III, the instruments that have been adopted by the Council, and finally a summary description of the main elements of the regulation implementing the enhanced cooperation. In July 2006, the Commission submitted to the Council a proposal for a Council regulation amending Regulation 2201/2003, the so-called Brussels IIa, applicable as regards jurisdiction and introducing rules concerning applicable law in matrimonial matters. The Commission's proposal was thoroughly discussed in the competent working party of the Council, and the discussions showed that the proposal was problematic for certain member states, but at the same time very important for other member states. The negotiations revealed that unanimity could not be reached. On 5th and 6th June 2008, the Justice and Home Affairs Council therefore took note that there was a clear lack of the unanimity needed to go ahead with this regulation, and that there were unsurmountable difficulties that made unanimity impossible, both then and in the near future. Between July 2008 and January 2009, a total of 10 member states addressed the request to the Commission, indicating that they wished to establish the enhanced cooperation between themselves in the area of applicable law in matrimonial matters, and asking at the same time the Commission to submit a proposal to the Council to that effect. In April 2010, the Commission submitted two proposals to the Council. The first proposal that the Council adopts a decision authorizing enhanced cooperation in the area of the law applicable to divorce and legal separation. That first proposal was adopted by the Council by unanimity, and I underline by all Member States of the European Union, with the consent of the European Parliament, less than 3 months after its submission to the Council. It was the first time ever that the Union adopted a decision authorizing enhanced cooperation in the area of Union law. The Commission also submitted a proposal for a Council regulation implementing enhanced cooperation in this area, that is setting out the specific rules that should apply in relation to the law applicable to divorce and legal separation. One of the main objectives of that proposal was to provide citizens with legal certainty, predictability, and flexibility. Indeed, it is a well-known fact that in matrimonial proceedings of an international nature, national laws are different, especially as regards conflict of law rules. These differences make it very difficult for international couples to predict which law will apply to their divorce or legal separation proceedings. This may lead to the application of a law with which the spouses have only a slight connection, and to an outcome that does not meet their legitimate expectations. The rules set out in the regulation are applicable only in the participating member states that are bound by the regulation. The treaty lays down strict conditions which must be respected in order to protect the values of the Union and the interests of the non-participating member states. In particular, it is worth mentioning three conditions. Firstly, enhanced cooperation may not undermine the internal market or the economic, social and territorial cohesion of the Union. It may not constitute a barrier to or discrimination in trade between member states and cannot distort competition between them. Secondly, it must respect the competencies, rights and obligations of those member states that do not participate in it. The common conflict of law rules in the participating member states cannot affect the rules of the non-participating member states. The courts of the non-participating member states will therefore continue to apply their existing domestic conflict of law rules in order to determine the law applicable to divorce or legal separation. Thirdly, enhanced cooperation cannot affect any pre-existing acquis that is already adopted by Union legislation. On the content of the regulation, and this is the third and last part of my intervention, it should be said from the outset that there is full consistency on scope and in acting terms with the Brussels IIa regulation. Four main aspects of the regulation on Rome III are worth highlighting. The first one is the material scope of the regulation. It applies only to the dissolution or the loosening of marriage ties. Preliminary questions, such as legal capacity or the validity of the marriage, should therefore be determined by the conflict of law rules applicable in the participating member state in question and are not regulated by the regulation. Moreover, the law designated by the regulation is the law applicable whether or not it is the law of a participating member state. This means that, for example, a court seized in Paris should be able to apply the German law or the Australian law in accordance with the rules set out in the regulation. The second aspect is that the regulation lays down uniform rules on the parties' choice of the law applicable. This means that the parties can agree to designate the law applicable to their divorce or legal separation within a limited range of possibilities. They can decide to choose the law of the state of their habitual residence at the time the agreement was concluded, or the law of the state where they were last habitually resident, insofar as one of them still resides there, the law of the state of the nationality of either spouse, or finally, the law of the forum. Where no applicable law is chosen by the parties, and with a view to guaranteeing legal certainty and predictability, the regulation provides for a scale of successive uniform connecting factors based on a close connection between the spouses and the law concerned. That law is, in the first place, the law of the state where the spouses are habitually resident. Failing that, the regulation provides for a list of other connecting factors taking into account the best interests of the parties involved. Should the courts always apply the law chosen by the parties or as defined by the regulation? The answer is no. It may happen that in certain situations the foreign law must be disregarded. This may be the case, for example, if the foreign law does not grant equal access to divorce or legal separation on grounds of gender, or in exceptional circumstances where the application of the foreign law in a given case would be manifestly contrary to public policy. Finally, it must also be said that nothing obliges the courts of a participating member state whose law does not deem the marriage in question valid to pronounce a divorce by virtue of the regulation. If the marriage concerned concludes in another member state or in a third state is not valid, for example, in Italy, nothing will oblige the Italian courts to pronounce the divorce. This stems from the fact that the existence and the validity of a marriage is a preliminary question to be ascertained by the rules of the member state where the court is seized. As a conclusion, I would like to recall that Rome III was the first instrument on enhanced cooperation ever adopted by the European Union. The basic idea was to create a regime of applicable law that could bring more certainty and predictability to the spouses at a difficult moment in their lives in a situation of divorce or legal separation. The regulation is already applicable to a considerable number of member states, and this without affecting the non-participating member states or the fundamental cohesion of the European Union. It is to be expected that the Rome III regulation, applicable from the 21st June 2012 to 14 member states, will be applicable in the future to 19, 20 or 21 member states of the European Union.